Of you. Good to meet all of you. I'm anxious to participate.
Good.
I hope you'll bear with me as I get to know you guys and the process.
You bet. And hopefully they won't have any lingering anxieties once the meeting is over. So, okay, now I'm running behind here. I need to get my stuff up, which I'm not able to do. I have to pull up my where are you? Here it is. My agenda and all that sort of stuff. Okay. Right there. Oh, come on. Public meeting materials. There we go. All right. Oh yeah, roll call. But if I don't go with this, I lose it. So meeting is called to order, and let's call the roll. First is Commissioner Baker.
I'm here.
Good. I'm glad to hear that and see that. Commissioner Bluestone.
Here.
Likewise. Commissioner Castillo.
Here.
Commissioner McMillan.
I'm here.
Commissioner Solomon.
Here.
Thank you. Good morning, Ron. And Commissioner Villanueva.
Here.
Great. Let it not be forgotten that the chair is also present. And I've already skipped over, but again, Dr. McMillan, if you want to say anything further upon your welcome or just reserve your comments for later or keep them to yourself, whichever is your preference. But I don't.
Yeah, thanks for the opportunity. I'm really excited to participate in the commission. Its function is important. I'm pleased that Senator Bucket chose me to serve in this way. Look forward to getting to know you guys.
Likewise. Thank you very much, Doctor. And we'll go now to item number 3 on the agenda, which is approval of the agenda. Is there a motion?
Adoption.
Is there a second?
Second.
Chair, before that, the staff would seek a few amendments. We need to do a couple of cleanup based on something we missed and something we need to take off.
Go ahead.
All right. So I'm asking for a motion to amend the agenda to do the following. So first on item 13B, the Rolona case involving Acosta, we need to take that off and then take off its corresponding item in 17B.
Okay. And as to that, I assume that the movement and the seconder are okay with that?
There's more.
Sir.
Okay. Well, let's do them serially just so we get them right. Okay.
All right. Next, we need to take off administrative complaint number 2023-18. That's item 15B.
Okay. Again, any objection by the movement and the seconder?
No.
No objection.
Hearing, and that amendment is part of the motion now. Go ahead.
Right. Corresponding to that, we also need to remove 19B, which would be the action that was related to that item.
Stuart, Judy, any objection?
None.
No
Thank
objection.
you.
Thank you.
And then last, we need to add 18D, administrative complaint number 2023-035. And we need to add Ms. Randall's name behind Mr. Boyd's name regarding settlements in administrative matters under the State Ethics Commission Act.
Okay.
Fine.
Okay. All right. So with those 3 amendments having been accepted by the movement and the seconder, is there any further discussion of the agenda? Hearing none, I'll ask approval. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner McMillan? I'm sorry, Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
And Commissioner Villanueva?
Yeah.
Thank you. And the chair votes yes. So the agenda is, as modified, approved. Moving next to item number 4, approval of the minutes of the August 4th commission meeting. Is there a motion in a second?
So moved.
Okay. Any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Castillo,
Yes.
Commissioner McMillan.
Yes.
I don't suppose you can approve them because you weren't here, but that's okay. We're getting you used to saying yes, and that's the important. Commissioner Solomon
Yes.
and Commissioner Villanueva.
Yes.
Great. And chair votes yes. So the approval of the August 4th meeting having been completed, we will next move to item number 5, advisory opinion number 2023-07. Jeremy?
Okay, thank you, Chair. Before we touch that item, I was wondering if I could introduce to you
Yes.
new members of the staff.
Yes, absolutely.
Great. So Sharon, do you mind turning on your camera and unmuting?
Let's see.
Here we go. So you can see the top of there we go. So this is, I'd like to introduce Sharon Garcia. We just hired Sharon as the financial coordinator. She reports to Wendy and is learning all things ASD, and her addition to our agency already has been a phenomenal improvement in terms of what we're able to achieve and process. And Sharon, if you'd like to say anything, the floor is yours. Okay. Well, welcome, Sharon. And then next, Jane was present for the special commission meeting in August, and this is her first kind of regular commission meeting. So also welcome, Jane.
Yes, and thank you, Jane, for figuring out my problem this morning.
Yeah, no worries. It's nice to meet you all, and I'm excited to work with you. Yeah, nice to meet you.
Right. Thank you all, and we can get to the business. So advisory opinion 2023-07. At this point, commissioners, the staff have drafted a fair number of advisory opinions for you. And I think this one is probably my favorite of the ones that we've done so far. The question is very interesting, and I think this opinion is very important for the commission to consider an issue. It's a very important issue for our state. And so the question presented is, does the procurement code apply to a public body's selection of lawyer contracts where the lawyer is paid on a contingent fee basis? And both state agencies and local public bodies around the state have entered into contingency fee lawyer contracts where the state or the local public body has recovered an enormous sum, and the attorneys that were representing the government entity in those cases also recovered an enormous sum of money. And so the question whether or not the procurement code applies to the selection of these law firm contractors is very, very important. And the advisory opinion that's drafted concludes that the answer to that question is yes. And the reasoning is as follows. The procurement code applies to every expenditure made by a state agency or local public body, unless of course there's an exception in the procurement code to the code's application. And if we think about how contingency fee contracts work and how lawyers are paid in contingency fee contracts, if we break that down, I think it has to be the case that the lawyers are being paid by public funds, and thus the government entity is making an expenditure of public funds. There's kind of, if we look back to the history of contingency fee contracts, the initial idea was that the lawyer's fee, the sum of their fee, would be measured as some percentage, and they would only receive the fee if some contingency happened, such as if their client received a settlement or if their client received a judgment, that the contingent fee that the lawyer receives is measured by some amount of what the judgment or the settlement is. But over time, contingency fee contracts have evolved to where the contract creates what is called a charging lien, technically, where the lawyer and the client agree that when the lawyer receives the funds in trust for the client into the lawyer's trust account, that the lawyer can calculate and take their fee first and then send the balance to the client. And that's normally how contingency fee contracts work now. But when we think about the operation of charging liens and how contingency fee contracts in its modern sense currently works, it's still the case that the funds are the client's. It's still the case that the funds belong to the government entity. So even when the law firm is exercising its charging lien and removing its portion of the fee before passing on the balance to the client, they're still taking the public's money for their fee, and thus that's an expenditure of public funds. And so either way, if the contingency fee contract is the old style where it's just measuring the amount the lawyer is entitled to by a percentage of the recovery, or if it's in its kind of current iteration where the lawyer is taking their fee out of the recovered fund first and remitting the balance to the client, either way, there's an expenditure of public funds. So that's why the opinion concludes that, or the draft opinion concludes that the answer is yes. And then I want to kind of turn and mention a few of the assumptions that this is built on. Several state Supreme Courts have considered whether or not state agencies under their state constitutions can enter into contingency fee contracts. And in New Mexico, cases, we don't have that same kind of guidance, but it seems as though that, and what the opinion does for purposes of assumptions for getting to the procurement code question, the opinion assumes that the legislature can and has in fact authorized certain state agencies to enter into contingency fee contracts with law firms. They've done that in the case of the SIC, the State Investment Council, and the ERB, the Educational Retirement Board. And the New Mexico legislature knows very well how to authorize state agencies to enter into contingency fee contracts. They create statutes that create a suspense fund for the recovered monies to come into, and create legislation consistent with the Constitution that authorizes appropriations out of those suspense funds to the lawyers. And for where the legislature hasn't done that, it seems as though that the ordinary law in Chapter 6 would apply, which is when money comes in to a state agency in its custody or control, it has to be deposited into the Treasury. And then the legislature is the entity that has the constitutional authority to make appropriations out of the Treasury. And so the background law kind of suggests that it's uncertain whether or not state agencies can enter into these kinds of contracts, but certainly in the case of two agencies, the legislatures have authorized that. And so because the legislature has the authority to create or to delegate that authority in state agencies to enter contingency fee contracts, I think the opinion fairly kind of answers the procurement code question. When the legislature has done that, how should the selection of those law firms go? And so, Chair, that's the overview of this draft advisory opinion, and I'd seek a motion that you issue it.
All right, thanks. Is there a motion and a second? Then we'll move to discussion.
So moved.
Second.
Moved and seconded. Discussion. Let's go through in a somewhat orderly fashion. Commissioner Baker, since you're up on the screen, what do you have to say about this?
First, I thought the advisory opinion was excellent, very well thought out, well researched, and so forth. I really never thought that this was a much of an issue, quite frankly, because in New Mexico law, and I think it's across the country, a settlement belongs to the client. And then the lawyer gets paid by the client from those settlement funds. And so that there would not be a competitive proposal, competitive bidding to see which law firm would get the prize, if you will, of one of these contingent contracts bothers me. Typically, my understanding is these contingent fee arrangements happen when, for example, the attorneys general of many, many states get together and sue some big target. Most recently, New Mexico joined with others to sue the opioid manufacturers. And typically there is one, perhaps two national law firms which do the heavy lifting. And then they are, quote unquote, assisted by local law firms in the multiple states. And so the reality is that these local law firms really are not doing very much work, not doing very much heavy lifting, and get to share in a oftentimes very huge settlement. And the problem is that the Attorney General, if these competitive proposals are not in place, the Attorney General just picks one of his buddies and says, are you willing to sign your name to these pleadings? The answer is yes, and there's a huge payday. So I would say two things. One, the opinion is very well drafted, but second, assuming that the commission approves this advisory opinion, I would hope that we would use our publicist, Tom Garrity, and let every New Mexico agency, let the media know that this is the rule. This is the law that needs to be followed. And going forth, there are not going to be any friends of the Attorney General who get these lucrative contracts without at least having to go through a competitive proposal process. So I'm very pleased that this is on the agenda. I'm very pleased with the quality of the work. And I'm certainly going to vote in support of this advisory opinion.
Thank you. Commissioner Bluestone?
Thank you, Mr. Chairman. And I agree with Jeff's comments wholeheartedly. I think it's an excellent opinion. I thought it was very well researched and very well done. And I think I also agree with Jeremy. It represents an extremely important issue and is perhaps the most impactful of the advisory opinions this commission has ever issued. And certainly in terms of the potential dollar impact on the state, that's the case. With respect to the Attorney General's office, Jeremy, could you review for us what you understand the practice has been over the years with compliance with the procurement code or not? And if, well, let me leave it at that to begin with.
Here, and Commissioner Bluestone, I'm really not informed on that question. I will tell you that when I was in private practice, I was part of a team of lawyers that responded to an RFP for the opioids work, for Bernalillo County's opioids work. And Burnco was going through a request for proposals. And so I've seen that compliance at the local level, but I'm not informed on the Attorney General's office in this respect.
As I thought there was generally compliance with the procurement code with these major contracts that the Attorney General's office was issuing, but I haven't researched that myself or found out. I'd be curious to know. But I think the opinion makes sense, and I think it's well done, and I'm happy to vote in support of it. Thank you for your work.
Great. Thank you, Commissioner Bluestone. Commissioner Castillo.
I agree with both Commissioners Baker and Bluestone. I think it's an outstanding opinion. I think it provides the necessary guidance. And I want to commend you, Jeremy, for your fine work. And I certainly will be voting yes.
Thank you. So, Dr. McMillan, Commissioner McMillan?
Thank you. I'm in wholehearted agreement with Jeremy's argument. It would require a compelling argument to vote against this. And I'm not aware of that. So I'll be voting in favor. Thank you.
Thank you, Commissioner. Commissioner Solomon?
Thank you, Chairman. I don't have any additional comments. Thank you very much for an excellent opinion, Jeremy. Appreciate it.
Thank you.
Thanks, Ron. And Commissioner Villanueva. I always feel so bad because you're always the last one. But
that's okay. I'm used to it.
That's okay. You're the repository of all great thoughts, so it's just as well to come at the end.
Well, thank you, Chair. Yeah, the opinion was very well done, Jeremy. So thank you very much, and congratulations. I additionally want to thank Commissioner Baker for his additional thoughts on how this process works. And not being a lawyer, I was really enlightened by him. So thank you very much.
Thanks, Judy. And I echo everybody else's sentiments. It's very well done, and it's an interesting proposition, and one that has, I don't know how it hasn't caught somebody's attention up to now, I guess, but I'm glad that it did, and I'm glad that we were the ones that got the crack at it. So very well done. Thanks very much. Any further discussion?
The only thing I would add is what I said earlier. Assuming that this passes, I would hope that we ask our publicist, Tom Garrity, to make sure that this gets out to the public.
All right. Thank you. So let's call the question. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
And the chair votes yes. Motion carries. So let advisory opinion 2307 issue. Thanks again. Wonderful work. Okay, on to the next matter, which is, I got to go back all the way up. Electronica is great, except you can't lay out pages. Oh, I should shut up because you probably can, and I just don't know how to do it.
Hey,
Okay,
Jane, you might be printing an agenda for Chair Lang.
She's tied up with somebody else's computer problem, it appears. All right, next is the matter of resolution 2305 having to do with commission media policy. I asked Jeremy to put this on the agenda because there have been several instances of individual commissioners wanting to or going forward with for publication their sentiments. And so how do we proscribe that where everybody's, if not happy, at least not unhappy? So Jeremy, I'll turn it over to you and Mr. Garrity.
Sure. Well, Jeff spoke of Tom Garrity, and here he is with us today. Tom is on a contract with the Commission for Public Relations and has done great work so far. And with Tom, we're developing a kind of media strategy, and the item before you is, I guess, part of that. And so, Tom, I'll turn it over to you.
Great. Thank you very much. Chairman Lang, commissioners, I appreciate this opportunity to work with the State Ethics Commission on a variety of issues, including this suggested draft media policy. The media policy is something that I provided some guidance and insight upon. The guidelines themselves actually provide the commission consistency, accountability, and protection for the commissioners themselves. Consistency from the process point that it provides a process for the Ethics Commission. It provides a process for staff. It also provides a process for the commissioners. As far as the accountability, it provides accountability for staff to respond to cases, to the commission, to represent the mission, vision, values of the organization, and provides a means for commissioners to speak as individuals. And then it also provides protection from the perspective of disclosing confidentiality provisions, protection from conflicting interpretations of a commission stance, and protection that could compromise commissioners' impartiality in its quasi-judicial appellate role in administrative proceedings. And so with that, Chairman Lang, commissioners, Mr. Ferris, I'll be more than happy to take any questions.
Thanks. It does come before us in the position of a resolution, which the commission will be asked to vote on. I will ask, just per the rules, that we have a motion and a second to adopt and then go into discussion. Is there a motion and a second?
So moved.
Second.
Thanks. Okay. Commissioner Baker?
I don't have any questions.
All right. Commissioner Bluestone?
Thank you, Mr. Chairman. Thank you, Mr. Garrity. I do have a few comments and questions. I like the resolution. The whereas clauses, I think, lay out the goals of the commission's media engagement being designed to keep the public well informed about ethics issues, and recognizing that we also sit in a quasi-judicial capacity on cases. But I'm concerned that some of the proposed guidelines are at odds with the goal of providing information to the public in a readily available format, and with the goal of educating the public, and not unduly restricting First Amendment rights of commissioners and being able to be responsive to media inquiries. So I guess I should go through the Exhibit 1, where I have questions and comments, if that's okay.
Yeah.
In the third paragraph of what's after the introduction in Exhibit 1, the second sentence says the chair speaks on behalf of the commissioners. And I certainly have trust and faith in our chair, but I think that we should have a clarifying clause at the end of that the chair speaks on behalf of the commissioners when authorized to do so. And I think that that's consistent with the authority that the chair has, and that we ought to clarify that so that there's no confusion about future circumstances. And as I say, I'm not trying to cast any aspersion at all on what our chair might ever say that could not be authorized, but I think that would be an appropriate clarification to add.
Stuart, can I interrupt and ask a question?
Yes, for sure.
So if a reporter calls Jeremy and says, asks a question, well, the commission has not specifically authorized Jeremy to speak with respect to whatever question the reporter is asking. So as a practical matter, if Jeremy cannot speak unless there's a pre-authorization, how's that actually going to work?
Well, I'm talking about the chair, not Jeremy.
Oh, I'm sorry.
I think Jeremy does have to speak as the executive director always. But if the chair is asked, what are the commissioner's views on this, that, or the other thing, I'm just saying I think that he can speak, but there should be an authorization for him to give public comments about things.
Well, then I'll have the same question with a little change. If a reporter calls Bill, asks a question, does Bill have to say, well, I'm not authorized to answer your question. I'll get back to you. And given how infrequently we meet, is there a kind of a problem with logistics?
Well, I think that raises the question of what is the authority of the chair. And I think that we have trust and faith in the ability of our chair to answer questions as chair. But in terms of him having the authority to say, well, the commissioners all believe this or the commissioners all believe that, I just think it would be better to have a clarification, and he'll have to use his judgment. Depends on what the question is.
Yeah.
But he'll just have to say, well, I'm authorized to say this, but on this particular matter, if you're asking for general commission policy, I'd like to check back with the commissioners about that. So I just think it's a clarifying confirmation that he speaks for the commission when he's authorized to speak for the commission. And we may want to follow up and have other resolutions about what the chair is authorized to do. For example, I know we've given the chair authority to do settlements in a number of cases, not in all cases, but in a number of the cases. And I think that vests him with authority to speak on behalf of the commission when he's been authorized to approve those settlements.
Yeah, and just by way of, I mean, that's a good, I think a good question, Jeff. I follow what Stuart is saying. I mean, if I'm uncomfortable answering that it's something beyond, yeah, we all met, we did discuss this, and this is the outcome of it, something pretty vanilla like that, or basic procedural stuff, it would be foolish to respond to a member of the press otherwise than saying, that's a good question, but I think it's one that needs to be taken up and has not yet been considered by the commission. I'm uncomfortable speaking to that, absent said conversation. I'll get back to you. I mean, there are multiple levels of protection for the integrity of the commission and for my own bona fides to just kind of have a place where a safe harbor where I can go back. But it makes sense. I mean, most stuff is going to be, I would say 90% of it is going to be pretty generic stuff that I'm comfortable doing. But if in the least, I feel like maybe this should be taken up by the commission, or it's something we had not before considered, then it would be foolish, if not just unwise, to not bring it up to you folks.
Yeah, I understand that. I just don't want there to be a policy that says the chair cannot speak unless pre-authorized.
Yeah, no, I don't disagree with that, because that makes it, I can't simply say, yes, the sun is out, according to the commission. Yeah, and I think Stuart recognizes that. So we have to be careful what is proscribed in there.
Yeah, I think that's right. The next point that I'd like to raise, I guess, comes up in the following paragraph about commissioner contacts and responses to the media. And what I'm thinking about is whether we need to add something to be explicit, that if a reporter calls a commissioner to ask the commissioner about comments that the commissioner made in an open public portion of the meeting, or a vote that the commissioner took in an open public portion of the meeting, for clarification on the commissioner's comments or the commissioner's votes, it seems to me that consistent with the First Amendment rights of freedom of speech, and with trying to advise the media and the public, that we want to be clear that if somebody asks a commissioner what you meant when you said this at the meeting, or why you voted this way, that there ought to be an opportunity for the commissioner to be able to respond, to provide information to the public, rather than not. And I'm not sure that paragraph it includes that. And I'd like to see a statement to the effect that commissioners may respond directly to news media requests to clarify comments made or votes taken in open public sessions, consistent with these guidelines. I'm not trying to say that we shouldn't be aware of the concerns for having not violate any of the confidentiality rules or otherwise, but I think that there should be a statement affirming those opportunities. And I just wondered what Mr. Garrity, Jeremy, thought about that issue as well.
Well, let's ask them.
Well, I'll start. I think that proposition has a place in this media policy, Commissioner Bluestone. So long as the other parts of the policy are there in place to really ensure that when a commissioner does that they make it clear that they're speaking for themselves only and not for the commission as a body. And that protects the commission from any kind of apparent authority type argument that the commissioner is somehow binding the commission to some position, which is an important consideration. We're a government entity that sues, and one day we'll get sued. And so we have to be careful in terms of an individual commissioner binding the commission to some position. And I think so long as the commissioner is aware that when they respond to explain their vote or a comment, that they are entering into a kind of dangerous area, because so much of what you do and consider is confidential and is backed up by criminal sanctions. And so long as the commissioner is aware of that point, and so long as the commissioner kind of clarifies that they're speaking in their own capacity and not on behalf of the commission, I think that the proposition you raised makes sense.
Thank you.
Mr.
Mr.
Garrity,
Garrity?
do you care to add anything to that or modify it?
Just some additional insight, Chairman Lang, Commissioner Bluestone. With respect to, as a public relations practitioner, one of the things that I like to see is just containment from the perspective of, if we don't have to add additional comments, then we shouldn't. And so if it's possible, if a commissioner is, for example, asked about some comments that were made or position or to explain their vote of comments made in the context of a public meeting, I think that that's fine for the commissioner to say, to defer to their comments in the public meeting and say, I have nothing further to add to my previous comment, things of that nature. I think the challenge becomes that when a commissioner could potentially bridge that gap of expanding upon their comments as a commissioner, explaining a vote, and how that could get mixed into their personal views as an individual, it clouds that from a perceptual perspective. I'll defer to Mr. Ferris with respect to from a legal perspective, but from a perception, as soon as additional comment is provided, there's always that opportunity for members of the community, members of the media to look at that comment and make their own discernment whether they're speaking on behalf of the organization or on their own personal behalf. So my preference would be that the comments by commissioners are limited to those comments that are made in the meeting.
Thank you.
Well, I think that we don't need to do the actual wordsmithing right now in this meeting, but I think Jeremy and I at least are in agreement on putting something in that would allow commissioners to respond to media inquiries consistent with these guidelines and with the need to be sure that no confidentiality rules are broken. I'm not sure that Mr. Garrity and I agree that a commissioner should always just say when a news person asks for a comment that was made in a public session that the commissioner says that they have nothing more to add than what they said in the public session. So I think I'd like to have an opportunity to work on this a little bit with Jeremy and Mr. Garrity and see if we can come up with some agreement on how to do this. and acknowledge still First Amendment rights that I think need to be taken into account.
Yeah, that makes sense. And we're not in any great rush, I don't think, to get this out.
Okay.
At any moment. Stuart, if I can just dovetail onto something that Mr. Garrity said, in said drafting, concerns about further comments are different from what Mr. Garrity's are, but there's always the issue that something that is said may down the road cause a perception or perhaps taint that particular commissioner's ability to be perceived to be acting neutrally in that or a similar type of event, which would hamstring the commission's ability to work on that particular issue. And there's no way to forecast when that's going to happen. But you say something now, and 2 years later, somebody brings that up, and it presents a problem when you have just acted on a similar type of case. And that's the sort of thing that I suppose we're all at some level trying to prevent. But in capturing the appropriate language, I would hope that that's kept in mind.
Yeah, good point. I think the next comment I'd like to make gets to the guidelines for the commissioners when engaging with the media. And again, I don't think we need to wordsmith it in every respect, but I would rather that very first sentence read, instead of commissioners must clarify that they are communicating as individuals and not as official spokespersons, to have it read more that commissioners should clarify when they are communicating as individuals and not as official spokespersons for the commission, unless the commission has granted approval of the statements expressed. For example, we also have in our public materials an op-ed that I've drafted that I would like to have the commission review at some appropriate time and maybe endorse, so that it could be identified as something that's approved by the commission. And I just think that adding in that opportunity for the commission to have something to review and approve is consistent with what I think these guidelines are intending. And then there would be some follow-up editorial suggestions I would have, but I think that same clause, that unless the commission has granted approval of the statements expressed, should also be added in the second guideline, where it says avoid official title, where the commissioners should refrain from using their title as state ethics commissioner to identify themselves in opinion editorials or related media communications. And then I'd say, comma, unless the commission has granted approval of the statements expressed. So I'd like to be able to work with Jeremy and Mr. Garrity to see if we can build into these guidelines the opportunity for the commission to review things in advance and then have the statement be approved by the commission. So that's what I would add on those two. And I guess the same point that I was making before about responding to media inquiries comes up with item number 5 on avoiding direct inquiries. I'd rather state that as a general rule of commissioners not responding directly, but I think, again, we need to provide some explicit language that the commissioners may respond directly when they're just asked to explain a comment made or a vote taken in an open public meeting. and that these statements should not be absolute bars, but should be general rules so that there's some opportunity for commissioners to respond directly to news media who are often operating on tight deadlines and without violating the overall thrust of what our guidelines are in terms of protecting the commissioners and the commission, particularly with respect to confidential information. And then I'd like the same clarification that the number 6 item on the review by the executive director should be a general rule, but not be an absolute bar or a, if you will, a gag rule that would prevent commissioners in any and all circumstances from talking to media outlets. There's also a typo, by the way, there in number 6, where the last line says does not violate confidentially provisions. That should be changed to confidentiality provisions. But maybe my most important point is the one on number 9, where it says, with respect to staff media communications and commission approval, that there may be infrequent and exigent times when the commission staff wishes to draft a letter to the editor or an op-ed or other piece. I disagree with that. I think that part of our role as a commission is to advise and educate the public about governmental ethics issues. And I do not think we should limit op-eds by commission staff to infrequent and exigent times. And when we get into the discussion later about our strategic plan, I'd even like it to be more explicit that we set a goal of something like 3 op-eds a year at a minimum to advise the public about what the commission is doing and about important issues of governmental ethics, because I think that's an important role for the commission. And so I think that rather than limiting commission staff to only infrequent op-eds, we ought to be encouraging the outreach to the public with op-eds and other statements of general application. And there may be, and there have been, court decisions that have been issued on the Campaign Reporting Act and other things, where I think the commission staff can provide a helpful guidance to the public on what these important decisions mean. So I have, I guess, my most fundamental disagreement with this item number 9, and would like the opportunity to talk to Jeremy and Mr. Garrity and come back to the commission with a revision to have considered for being sure that commissioners can speak in certain circumstances, but definitely set up the guardrails that are designed and effective to prevent the disclosure of confidential information, but also keep in mind the fundamental role, and it is a very fundamental role, I think, for our commission staff and us as commissioners to speak out on ethics issues and to educate the public about governmental ethics matters.
Chair and Commissioner Bluestone, if I might, with respect to paragraph 9, your fundamental objection, I think it's based on a misunderstanding. I don't read this to suggest that the commission staff will only infrequently and exigently write letters to the editors or op-eds. I just point you to the clause as a statement of the commission as a body. So that's kind of, if the commission were in the same position like it just did, issuing an advisory opinion where the whole commission votes on a particular piece of writing. That's what the paragraph is geared toward, the preparation by the staff of a document for publication in the news media that the staff wants to present to the commission and have the commission authorize it as this is the statement of the Ethics Commission on this issue. That's what I imagine is infrequent, as opposed to the ordinary staff exchanges with the media across the commission's work.
So you're saying that, for example, if now that we've approved the contingency fee opinion, that you would like the leeway to write an op-ed on what that opinion stands for? Is that what you're getting at, Jeremy?
No, that's not what I'm getting at. What I'm getting at is there might be infrequent times when the staff prepares a letter to an op-ed, for example, and wants the commission to treat it in the same way that the commission treats a formal advisory opinion, where it's presented to the commission as a document and approved by the whole commission as a body, and then is sent to the media as the commission's official statement on some issue, not coming from the staff, but coming from the commission as a body. That's what paragraph 9 is about, and that's what I think would be infrequent, and perhaps limited to kind of exigent times. Does that make sense?
Sort of, but I don't think we want to try to, as I say, redraft this right now. But I think I would like to work with you so that you feel, and you do have the authority to send out an op-ed like on what the commission just approved, or write op-eds on Court of Appeals decisions, U.S. Court of Appeals decisions that are issued. So I'm happy to talk to you more about this, but I am a little confused, and I think the language in that provision may not get to what you're trying to express there.
Okay. Jeremy, are you
And those
there?
are my main points.
Thank you, Stuart.
Thank you for your indulgence and your time. Sorry it took so long.
No, it's okay. Commissioner Castillo?
Yes, I've looked over this policy, and I think it's a good idea for us to have a policy with regard to communication. And as always, the devil is in the details. There are a couple of areas that I think need a little more wordsmithing. And I'll start with the first one. It's the third paragraph on the exhibit, where we say that the executive director or communications manager facilitates news media inquiries and speaks on behalf of the state ethics commission. And that's fine. And then it says the chair speaks on behalf of the commissioners. I don't think the commissioners are separate from the commission. I think if we take an action, we take it on behalf of the commission. So I think I'd like this clarified to say that the chair speaks on behalf of the commission too. Then we have down at the bottom of that particular page, I really like the language that talks about why we're doing this policy, because we don't want to have unchecked media communications that would lead to conflicting interpretations of the commission's stance on certain issues, and could compromise the commission's commitment to bipartisanship, can't even say the word, or the commission's impartiality in its quasi-judicial appellate role in administrative proceedings. We have a variety of roles as commissioners, and it's important that we have a policy that makes sure that we protect all these different roles and then act as a commission. If an individual is acting as an individual, that needs to be abundantly clear. And I understand what Mr. Garrity is saying, that sometimes our audience doesn't make that separation. And it's important that we make that abundantly clear. With regard to that particular paragraph, maybe it ought to be at the front of this policy to let people know why we're doing this. Then when we get into the guidelines, I have a question on number 3, conflict of interest disclosure. commissioners should disclose during the open part of commission meeting any potential conflicts of interest related to the topics they intend to address in media communications. I'm just a little unclear as to what that means, and maybe you can help me, Jeremy.
Well, Chair and Commissioner Castillo, I think that the origin of that guideline is from similar media policies that we reviewed. And Tom, if you don't mind speaking to conflicts of interest disclosure as a normal part of media policies, that'd be helpful.
You bet. Thank you very much, Commissioner Castillo. That particular language is designed to just provide permission, for lack of a better term, to a member of a board who wants to disclose that they're going to talk on this, one, or two, that they have some other prior conflict. Perhaps it's something to do with a current employer of a board member or a commissioner, or a current contract, because everybody has day jobs, so to speak. So this just provides that opportunity to provide just any conflict of interest on the front side. Again, in the spirit of wanting to make sure that the entirety of is included in the meeting, and that way, the commissioners and/or any other members can just point to their comments from the board meeting for additional clarification.
Thank you.
So this means if I'm going to speak as an individual on a topic that is not, the commission has not taken a position, or the position is different than the one I'm going to speak on, then I have to, in the meeting, explain what I'm going to do. Is that what you're saying?
Yeah, if you, Commissioner, yes, if you intend to address it in the media, let's say it's an issue that is particularly close to a commissioner, then letting others know that you're going to be, or someone is going to be speaking on this, is the intent of it. Is just to have everybody just be aware that what's could potentially be happening.
Okay, so we need to disclose our conflicts of interest anyway.
Mm-hmm.
So this then would relate to, yeah, go ahead.
I'm sorry, Commissioner. Yeah, so let's say a particular topic is brought up, and a reporter has been doing some investigation on a particular story, or a member of the community has asked, and it was on basically on a separate path than the path of the complaint that is being considered by the commission, or the issue that's being considered by the commission. It would just provide an opportunity for the commissioner to say, I have been approached by a member of the media on this particular issue. They have their own perspective on this that they've shared with me, or some additional information, and just provide an opportunity for that to be known.
Yeah.
Thank you. Commissioner Castillo?
Yeah, I'm just a second. Let me look and see if I have other.
Okay, sorry, I didn't.
No, I marked up my copy, and that's what I'm.
No, but the screen was stuck on Mr. Garrity.
Oh, okay.
Looking woefully unhappy that he was stuck there with nothing to say.
I think those are my basic comments, and I guess I like the idea of, since there's a rush on this, maybe taking it back and making some changes to make it clearer and address some of the issues that we've talked about today.
Thank you. Commissioner McMillan?
Thank you. I will be brief. I think it appropriate that perhaps further revision take into account the points made by Mr. Bluestone and Commissioner Castillo, be taken into consideration that this be brought back to us. I have less concern personally in my function on this commission with respect to my own free speech rights. They do need to be included. They need to be discussed and debated. I'm very, in my own experience, very cautious about interacting with the press. My function as an individual commissioner cannot in any way be allowed to undermine the function of this commission. And so I'll have no problem, for the most part, in deferring to the chairman in rendering in his judgment opinions or questions directed about decisions made by this commission. I'll also have no problem with going through the executive director with respect to any particular communications I want to make with the press. So yes, it's a wonderful debate, and I'd like to see the refinements when they come back.
Thank you, Commissioner. Commissioner Solomon.
Well, thank you, Mr. Chairman. Want to thank Tom for drafting this for us, Tom and Jeremy. I think it's a policy that's definitely needed for protection of the commission's decision-making processes, as well as the individual commissioners. You know, sometimes I know that we have been challenged to maybe be outspoken and either respond to any kind of media requests for individual kind of takes on matters that we've decided. You know, there's subtle inquiries that are made sometimes too out in the general public, because we, most all of us here, walk in wider circles than just the commission realm. And so when you're out there, there's, you know, people among the different circles in which we walk that are curious about decision making, and of course our votes really are on the record, and they're made for public consumption, if you want to put it that way. But I think there's a, you know, from my standpoint, and I really come from a cultural standpoint as well, in the context in which I've worked and provided advice and assistance on matters that are out in the general public. And I'm really speaking something that goes back hundreds of years now for the people from whom I come, and that's among the Pueblo nations here in the state of New Mexico. And practice has always been, at least in the populations in which I've worked or worked for, that when a matter is decided, even if you weren't in the majority, that is what you stand for. And in fact, there's an affirmation process that goes on where there's been a vote, and you know, it's not a unanimous kind of vote, where the expectation is that you would affirm the vote of the entire body. And so that's something that's part of my core values, you know, to begin with. And then I look in this, you know, this Western concept and the judicial framework overall that we work in, and this, of course, this administrative body that we're part of here with the quasi-judicial kind of functions that we have. And it's I think going to be continually important that or continuously important that we have a spokesperson to represent the decisions of the commission. Like Terry, I have no penchant for that kind of media exposure to express my own personal views on what transpired in terms of decision making as it affects individuals and the kind of constituency perhaps that they represent. So I, you know, with regard to the guidelines and the other comments that have been made, I think there is a need for additional review and some editorial aspects that need to be placed in the language that currently is drafted. But I hope I'm making myself clear, and it's probably a much more conservative view as compared to my fellow and much admired Commissioner Stuart Bluestone in regard to First Amendment rights. But I just in this kind of body, I feel that the more self-contained and self-constrained that we are, the better off I think that we'll all be as a commission, and we'll be able to execute our duties, without any kind of constraints or feeling compelled to, get out there and express our own opinion of our combined decision making. I'm with Stuart, though, on the advice and the educate aspect of our functions as a commission and through our staff. And I think, by and large, from everything we know about the way that we functioned, we've done that fairly well. And now we're in an area, I think the whole procurement code arena is something that there needs to be a lot of education provided to the public, and especially those that are in key responsible positions within the administrations of the state and its sub-agencies. So that's my input, Mr. Chair. I appreciate it, and thank you, Tom, again for the work that you've put into this to provide guidance and a policy for us to abide by.
Thank you, Commissioner Solomon. Commissioner Villanueva.
Thank you, Chairman. I joined Commissioner Solomon in being the other conservative on this matter. I think this is very important, and I think I'm glad it's being addressed at this point. I believe that this document is a good start, but given the very interesting and diverse opinions that we've heard, I'm looking forward to seeing some clarification on another draft on the next document and some revisions that I think are needed with respect to some of the things that the commissioners have mentioned. In particular, the guideline number 3, which I agree with Commissioner Castillo, is still not clear to me. So I just wanted to thank you so much for addressing this at this point in time, and I think it's important that we have the time to look at it carefully so that we might come up with a document that works.
Thank you, Judy. Thank you, everyone, for your comments. It would appear from my reviewing the comments that there is a pretty healthy appetite to perhaps table the motion and refer this matter to what I would call loosely, if not officially, a subcommittee to work on the wordsmithing, as everybody calls it, given the levels of interest that certainly Stuart has, and never do anything involving wordsmithing that doesn't involve Commissioner Villanueva has been one of the things I've learned over the years in this position. So I would suggest that a working group subcommittee, call it what we will, of Commissioner Bluestone, Commissioner Villanueva, and Commissioner Baker work in tangent with Jeremy and Mr. Garrity to come up with something that incorporates all of the concerns that we've heard today, and I think that can be done, and bring it back to us at the appropriate time. Is there anybody want to speak in opposition to that? Jeff, you don't count. You're on the committee, so don't complain about it, please. There'll be a donut involved for you from me at some point.
Okay. Now we're on the same page.
All right. I knew it. Jeff and I discovered the perfect cinnamon donut one day. So anyway, does anybody think it's a bad idea, a good idea, it needs to be expanded on?
Chair, we can do that.
Everybody okay with that? Stuart, are you good with that?
Yep. Thank you.
How about you, Judy, since you've been thrust into that position, but you're just too good at what you do? So
no, I'm just so used to being thrust everywhere. I'm good.
It would be just an absolute ludicrous for me to not put you on something that didn't involve making good writing better. How's that? Okay.
Thank you.
Thank you. How about we take a comfort break? Everybody okay with that?
Sure.
Let's stand down for 5 minutes and we'll come back on. Thank you.
Thank you.
Everybody back? I see that Stuart is.
Yes, sir. Everyone's here.
I am.
All right. Let's go back to now item number 7. Stuart, this is you, and in light of our last discussion and what to do with it, I don't know if you want to hold that back or if you want to go forward. I don't know, but it's your call.
Thank you, Mr. Chairman. Let me just make a few comments, and then I think we can move on. I'd rather the commission have a media policy adopted, and I agree that we should work it over. But what I have written here, as Commissioner Solomon noted, is a draft of an op-ed addressing what I think we have recognized as an increasingly important issue for us on the commission, and that is getting public education out about the procurement code and its importance. And once we have a policy in place for media contacts, I would like to present this to the commission for their approval so that I could release it as a document that I've written as a state ethics commissioner and that the commission approves. If at some point we take a vote and it's not approved, I'll release it at an appropriate time, just as my individual capacity, and have appropriate disclaimers that it's not a statement on behalf of the commission. But in doing the research about this, after we've had discussions about different procurement code matters that have come to us, advisory opinions we've issued before, cases we've dealt with, certainly the important advisory opinion we just approved earlier today that Jeremy brought to us, I think that the procurement code is a very important issue for us to be providing information to the public about, and to emphasize its importance and its requirements. And I learned in talking to one of the fellows I consider to be a real expert on the procurement code, an attorney named Cliff Reese, that most of the procurement code work around the state is done in the springtime. After the legislature has met in January, February, March, and approved a budget, and the governor has signed the bill, and House Bill 2 has been enacted into law, and the appropriations are known to the state agencies for what's available for the next fiscal year starting July 1, then agencies are actively involved in issuing RFPs and putting out for bids matters that they have the funds to award and to provide appropriations for public projects and public services. And so I think that's, with that in mind, it makes sense to publish something like this in the springtime when that work is most actively considered, in order to get the contracts in effect as close as possible to the July 1 fiscal year start of the next fiscal year. So with that in mind, I'd be happy to answer any questions about the draft that I've circulated, but I'd rather hold off asking you to vote on it until later in the year, hopefully when we do have a policy in place, and to ask for your approval to issue it on behalf of the commission. And if for any reason the wisdom of the commission is not to do so, that's fine, and I can do it as an individual. But my current plan is to wait and do it in the springtime.
Okay.
So thank you, Mr. Chairman, for that opportunity.
Thank you, Commissioner Bluestone. Anybody want to weigh in on the invitation to comment on it, or you want to wait until we take it up following the adoption of a media guideline resolution? Anyone? Okay, and so we'll just back that up and hear it at the time that we roll up the media resolution. Thank you, Stuart. Okay, number 8 is Commissioner recusal procedure. Commissioner Baker.
Thank you. Part of the material we received was the strategic plan for fiscal year 25. And on page SEC 63 of the material, there's recusal and disqualification of a commissioner. And then it sets forth the times when a commissioner needs to recuse because unable to make a fair and impartial decision, or in which there's a reasonable doubt about whether the commissioner can make a fair and impartial decision, when a commissioner has a personal bias or has prejudged a disputed evidentiary fact. And then at subsection H on page SEC 63, it says the commission shall promulgate rules for the recusal and disqualification of commissioners. And what I would like to see is that when a commissioner decides to recuse, that the commissioner state the reason why a recusal is appropriate, and not simply say, I'm going to recuse, because that doesn't tell the public why. It leaves the issue somewhat opaque. And I'm one of those people who thinks, I think in bumper sticker slogans much of the time, like sunshine is a wonderful disinfectant. Well, if the commissioner tells the public, I'm going to recuse because of X, Y, and Z, that provides the public with more information about what the commissioner is doing than simply having the commissioner say, I'm going to recuse, I'm not going to vote on this matter. So I just like the commission to consider a requirement that when any of us recuses, we say why.
Yeah, may I ask you, are you bringing that in the form of a motion for the commission to adopt that? Okay.
Sure.
Is there a second?
Ryan, you're muted.
I'll second it.
Is there a second to Jeff's motion?
Second.
Yes, Chairman, I'll second.
Okay. All right. Any further discussion? Commissioner Baker, you have spoken with your usual eloquence on the subject. Commissioner Bluestone?
Thank you. And thank you, Jeff. In general, I'm in favor of that kind of disclosure as well, but I'd be interested in learning how the recusal rules apply to judges and whether they state reasons or not, and what our current rule provides in terms of any statement that accompanies it. And maybe if you, Judge Lang, and Jeremy could answer those questions, I'd appreciate it.
Well, I think Celia and I probably had good experience with it. And the great phrase that I think we all relied on when I was on the court was that to avoid the appearance, even the appearance of impropriety. I am loath to go beyond that because there may be something that would, in the words of a former governor, open up a whole box of Pandora's that have nothing to do with anything the commission is dealing with, but could create problems where nobody else does. I think I don't understand why just simply recusing is not good enough. I don't give up all of my rights when I go onto the commission, but I'm perfectly comfortable saying to avoid the appearance of impropriety. You know, if it's a prior representation issue or something like that, maybe you want to, but I think that's entirely up to the individual to do that. So I don't necessarily, in fact, I don't agree with the proposition that we should state reasons therefore other than to say to avoid the appearance of impropriety. But Celia, you and I both had opportunities to do this. What are your thoughts on it? And besides that, serendipitously, you're the next person on the comment list.
I don't remember giving the reason why I recused, unless it was a specific reason that I felt needed to be explored.
Yeah, it was a one-off. Yeah.
Yeah. And so I guess I like your idea of leaving it up to the individual commissioner. There are times when I don't have any problem explaining why I'm recusing. There are other times that it doesn't make any difference. So who cares? And the impropriety is sometimes difficult to explain. And I think it's good just to say impropriety.
Yeah, to avoid the appearance thereof.
To avoid the appearance of impropriety.
Right. Yeah. Okay. Stuart, I think we're still on you. Unless
well, I was also asking Jeremy to explain our current rule.
I'm happy to do so. So the commission, y'all will remember in the very beginning, back in the winter of 19, promulgated rules on this. They're at 1.8.2 and 1.8.2.8 in the administrative code covers the grounds and the process for recusing. And it reads, a commissioner shall recuse from a matter in which the commissioner is unable to make a fair and impartial decision, or in which there's a reasonable doubt over whether the commissioner can make a fair or impartial decision, because the commissioner, and then you provided 6 examples of reasons why recusal would be appropriate. And then the procedure is simply that the commissioner sends the notice of recusal in writing to the director to recuse on a matter. And that decision is communicated to the other commissioners and is publicly disclosed in accordance with the disclosure provisions that apply to commission proceedings. So the way that this works in practice is when one of you recuses in an administrative matter, you normally send that in an email to me, and we post it on the docket, a notice on the docket that Commissioner so-and-so has recused from this matter, and it's on the docket. And if the docket is made public at some point in that administrative proceeding because the general counsel and a hearing officer have found that it's supported by probable cause, then the commissioner's recusal in that administrative matter is made public, just as in everything else in the docket is made public. And if it's not, if the general counsel concludes that that administrative case is not supported by probable cause and a hearing officer dismisses it, the docket's never made public, that recusal is never made public. It always stays part of our files, and we keep the files in all the administrative cases. And that's more or less how it currently works.
Would you also please read what those 6 provisions are?
Sure. So the first is because the commissioner has or appears to have a personal bias or prejudice concerning a party to the matter. Number 2, has prejudged a disputed evidentiary fact involved in the matter. That was drafted in the circumstance in the beginning to when we thought that individual commissioners might need to be assigned as hearing officers. And in the very beginning, when we were worried about our ability to actually have a budget and staff this statute. Number 3, has a pecuniary interest in the outcome of the matter. Number 4, has previously served as an attorney, advisor, consultant, or witness in the matter in controversy. Number 5, has served as a hearing officer in the matter pursuant to subsection of the administrative rules. Again, when we were thinking that individual commissioners might have to serve as hearing officers. And number 6, believes it is inappropriate to participate in the matter because of an actual or apparent conflict of interest or lack of impartiality in the matter.
Thank you. And My next question is for Jeff. Do you have in mind that if your motion passes, it would suffice, as the chairman suggests, to simply state, I believe I have an appearance of impropriety? Or are you trying to get some more disclosure, like, I know this person and can have considered them a friend before, or what would you think would be the goal of what you're trying to get in the motion?
Your second example is what I'm looking to achieve, specificity. Let's assume that person X has a matter before the commission. Person X is someone whom I have socialized with. I probably would do one of two things. I would either say, I have socialized with person X, regard person X as a friend. However, I believe I can be impartial. Therefore, I'm not going to recuse. You just put it out there so that it's a matter of public record. Or you say, I have this relationship with person X, and therefore I am going to recuse. We all have relationships with people. We all have histories with people. I want the Ethics Commission to be the example, if you will, for what other agencies do. I'll give you a real life example, and hope that it's not doesn't belabor the point. Most of you know that while I was still in practice, I represented Victor Marshall. Victor Marshall had cases in front of the New Mexico Supreme Court. One of those cases had former Governor Richardson as a defendant. Chief Justice Shannon Bacon, before she became a judge, when she was in private practice, she represented Bill Richardson. Victor Marshall wrote her a letter and said, I think you have a conflict. I think you should recuse. The Chief Justice never responded to the letter. He then submitted a motion saying, you have this former attorney-client relationship with Bill Richardson. You need to recuse. She did not respond. She then participated in a decision in which Richardson was a defendant. And then 3 days later, she recused. Never said why she did not recuse, never said why she did recuse. It's just opaque. It's a mystery. My view is, let the public know what's going on. In the words of former Albuquerque Mayor Marty Chavez, there are very few secrets worth keeping. Disclose about relationships. And this is why I'm not going to recuse. Disclose about the relationship. This is why I am recusing. And so my motion, if you will, is that we have a policy that says, if you're going to recuse, tell the public why.
Thank you, Jeff. And thank you, both Bill and Celia and Jeremy.
So, do you have anything else?
No, sir.
No, I don't.
Celia? I'm sorry, Celia.
I think that's it.
Thank you. Commissioner McMillan?
Thank you. At this point, I don't care to make any input. I've not been in a position yet to consider making a recusal from any situation. And so I appreciate hearing the arguments on both sides. Thanks.
Thank you. Commissioner Solomon?
Nothing further, Mr. Chairman. Thank you.
Thank you. Commissioner Villanueva?
Nothing further. Thank you.
Thank you. My comments have been made earlier, and I just would add to it that I think the more requirements you put on things, the more likely it is that you're going to miss something that you intend to prohibit from it. In this case, I think less is more. It serves an individual well. I can think of some instances, not of course in my own personal life, but others and ones I'm familiar with, where a relationship that individuals may have had in a previous life, so to speak, would come up, and it would serve no purpose for anybody that the specifics of it be disclosed. I just think there are too many unknowns with it, and you know, it suffices to me to say I don't feel that I can be reasonably thought of as being fair. There's a reasonable doubt as to whether I could be fair under the circumstances, and I therefore recuse. I think as it's set, it is sufficient, but we'll go ahead and call the question whether to adopt the recusal procedure as made in the motion in the second. Commissioner Baker?
I vote yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
No.
Commissioner McMillan?
No.
Commissioner Solomon?
No.
Commissioner Villanueva?
No.
And chair votes no. Okay, the motion fails on a vote of 5-2. Number 9, update on Financial Disclosure Act compliance.
Thanks, Chair. I'd like to bring KC in, and good morning, KC, and turn it over to you to update the commissioners on how we're doing Financial Disclosure Act compliance.
Okay. All right. Well, good morning, Chair, members of the Commission.
Good morning.
Morning.
Welcome, Dr. McMillan. So currently there are approximately 675 individuals who are required to file a financial disclosure statement under the Financial Disclosure Act. The majority of those are filed in January, or for individuals that are appointed, they're required to file within 30 days of the appointment, and then in January from there on. The Financial Disclosure Act requires the Secretary of State's office to first attempt to achieve voluntary compliance if someone hasn't met that January deadline. This year, following that process, the Secretary of State referred 118 individuals to the Commission on May 8th who had not yet filed. I would note that that's down from the 155 individuals last year who had not filed. June 2nd, we brought this issue to the Commission, and the Commission authorized staff to enter into pre-litigation discussions with individuals, and if necessary, to file civil enforcement actions in court. After we'd really reviewed the names of the individuals who had been sent over, we targeted a specific set of individuals. That included all of the state agency heads, all of whom are required to file, and members of boards and commissions who we deem to really be sort of the most significant as it relates to financial disclosures, that those boards and commissions where they control a lot of state money, they regulate industries that control a lot of money, that those are really the individuals that we looked at. We sent out a number of demand letters, and it became pretty apparent very quickly that there were some pretty significant issues with the campaign finance system that the Secretary of State's office has set up for this, that the responses that we started receiving were really sort of technical issues with the system, that there were issues that individuals thought they had filed, that they'd submitted everything but hadn't hit the file button, that they thought that they had registered but it hadn't gone through. There were individuals who never received their credentials, who they were forwarding me correspondence that said, you're registered, wait for your credentials, and then you can log in and finish this, and those weren't happening. And so after lots of conversations with filers, with the Secretary of State to figure out where these filers were, what had happened, sort of go back through the system and figure out where things had been filed and what hadn't, as well as a number of discussions with the executive directors and general counsels of these agencies. We were able to achieve compliance by all of the state agency heads and members of those really significant boards and commissions, the State Investment Council, the Board of Finance, the New Mexico Racing Commission. And we issued a press release to that effect on October 18th, which is available on our website. So through all this, we've really been looking at sort of how we can improve this moving forward. That really the goal is to have everybody have these on file. That voluntary compliance is set out in the act, that really what we want is this information filed. And so we've really been sort of talking about how to improve those numbers moving forward. First and foremost is sort of a little bit more awareness of the obligations that I've got to say that the general counsels and the executive directors I talked to who were involved with these agencies were super helpful, and hopefully sort of building those relationships as we move forward really help make sure that everybody's aware that they need to be doing these filings. The other piece of it is sort of logistically how to improve the campaign finance system. And so we did sit down with the Secretary of State's office. They're aware of these recurring issues that we raised. It's our understanding that they've been working with their developers, and they're expecting a large update in December to help address some of these problems. So our hope is that next year these numbers continue to go up, and that we continue to have increased compliance.
Great. Thanks, Casey. Anyone have any follow-up questions or comments on Casey's presentation?
Could I just add one thing, Chair? And it's sure. That, and I know that Commissioner Bluestone and Commissioner Castillo have asked about this in the past. We, after we achieved what we were able to achieve with respect to ensuring compliance with the individuals we targeted, we did issue a press release to that effect with respect to what the commission achieved. I believe Jane posted that on October the 18th, and that press release went out to our media contacts and perhaps was also even on Twitter. So we have announced the successes we've achieved in this case. And in the past, I had mentioned that some journalists were interested in covering this matter, and I was delaying a press release until the journalists had done their work, and that person decided in the end not to write a story on this, in part due to the problems with CFIUS and being able to verify what had in fact been filed and what hadn't. And so that's the only other update with respect to how we communicated our work to the public in this matter.
Thanks, Jeremy. Anyone, commissioners?
Sure. I want to thank you also, Caroline and Jeremy, for the work and the summary. I think it's very helpful, and I think you did an excellent job. I was glad we were able to get full compliance. I'm wondering, I know I didn't see any coverage of the press release that you issued. Are you aware of whether that was picked up in any newspaper around the state?
I don't think it was, Commissioner Bluestone.
Stuart, in my experience, it's not news when the planes all land safely.
Yeah. And in terms of the planes not being able to land on time next year, what is your understanding of what the Secretary of State's office is doing to try to make this CFIUS system more user-friendly so that we don't have this same number of non-compliant filings in the future? Are we in discussions with them? Is there any movement that you're aware of? I'm just curious what you've learned and what's going on there.
Yeah, so as I mentioned, we were able to sit down with the Secretary of State's office and their developer and really talk about these concerns that were coming up. And so I don't know precisely what the update will look like in December, but I understand that they're really doing some heavy lifting on making sure that the system across the board is a lot more user friendly, as well as user friendly on the front end, and then on the back end that it really serves its purpose of being a tool to verify those filings.
Thank you.
Chair and Commissioner Bluestone, the Secretary of State has asked for a meeting with me up in Santa Fe in the first week of December, and we have a number of things to talk about, and this is one of them.
Good. Thank you.
Yeah, that was a diabolically messy process. At one point, out of an abundance of caution, it appeared as if I had filed, but something told me I'd better double check it, so I had Walker go through it with me, and in fact, I had not, but all the indicators said that I had. So my sympathy is with those folks who felt likewise. I'm glad that the Secretary of State's office is working on that. So, anyone else?
I'd just like to reiterate what both our chairman and Commissioner Bluestone have said. First of all, thank you for all your hard work. This is a difficult project. It takes a lot of time, a lot of energy, a lot of conversations, and we really appreciate it because it's so important to get these disclosures filed. And I want to also thank you for being proactive, working with the Secretary of State, and looking forward to next year. So, I mean, it went down from what, 155 to 118, and maybe next year we can see it just in double digits or maybe even down to 0. So I just want to thank you again for all your work.
Thanks, Sue. Anybody else? Okay. Thanks again, Casey and Jeremy. Item number 10 is the budget request and strategic plan. Jeremy?
Okay, thank you, Chair. Commissioners, under Section 6B4 of the State Ethics Commission Act, I have an annual duty to present you with an annual budget and to submit it to you for your approval. We ordinarily do this by me providing you with the budget request in the winter in anticipation of the next session, and we're doing that again this year. So what you have before you is the Commission's budget request for FY25, which Wendy submitted to DFA and LFC in September. We've made some adjustments to what we submitted in September, which I'll tell you about. And the budget request that you have before you is what I presented to the LFC a couple of weeks ago. And it's what I intend to present to House Appropriations when the session begins. And so for FY25, which would start on July the 1st, we're seeking $1,676,400 in general fund appropriations. That amount of money would get this agency to 10 FTE. It would enable the hiring of an additional entry-level attorney position, a position that we don't have at the moment. So for the past 4 years, we've had classes of summer associates, law students, mainly from UNM, but beginning to be from other schools out of state. And it'd be wonderful to be able to recruit from our classes of summer associates, but we don't have a position to do that because we don't have an entry-level attorney position. And so that's the bulk of the expansion from FY24 is to ask for a general fund appropriation that finances all of the staff and adds one additional entry-level attorney position for 10 FTE. We're also seeking for the first time an appropriation of what in the finance world is called other state funds. And it would be revenue that we would receive from New Mexico EDGE, which is part of NMSU's Cooperative Extension Service. We've entered an agreement with EDGE to provide the trainings in ethics and procurement ethics classes that EDGE provides to government employees around the state as part of various certifications that they can receive. And in exchange for State Ethics Commission employees providing those trainings, EDGE is going to pay us. And in order for us to use that revenue and to bring it into our budget, it has to be appropriated by the legislature. And so Wendy and I were able to talk DFA into LFC and LFC into adding a $5,000 other state funds appropriation into our FY25 budget request after we had submitted. And last, as we've done in previous years, we're seeking $30,000 in budget adjustment request authority for settlement payments and sanctions that the commission receives in its litigated cases. And as you know, we've done that for a few years now. It's based on the way that the Attorney General's office brings in the consumer protection settlement funds and is able to bar that money into its budget. And we are asking for the same authority again on a very much reduced scale. And that's what the FY25 request looks like from the money side. Budget requests are also accompanied with strategic plans under the Accountability in Government Act. And you have the Commission's FY25 strategic plan before you. I'm going to highlight a few things that we're working on now and that we'll continue to work on through FY25. Some things that I'd like to see done in my first term as your director. The first is we're working now, and the work will continue through FY25 to create a better process for how we receive various kinds of complaints. So we receive administrative complaints through our proceedings portal. And as you are well aware, many of these are against local governments or otherwise outside of our jurisdiction. We also receive a lot of what we call informal complaints, allegations informing us of potential violations of the state's ethics laws that aren't filed as formal administrative complaints. And we are currently working on redesigning the website and the choice architecture of the website in a way to where we can route folks that really want to file an informal complaint in a certain direction to where it doesn't kind of begin the mechanics of the administrative process in the portal. And for those folks that do want to file an administrative complaint and are potentially comfortable litigating that administrative complaint themselves, that they continue to go through the administrative process in the portal. The former, the informal complaints, that ultimately goes down toward your authority to authorize civil enforcement actions. The latter, the administrative process, ultimately goes through your separate quasi-judicial authority to decide administrative claims. And because this commission kind of has two concurrent powers, one that sounds in the judicial, one that sounds in the executive, we're trying to make and design a better intake process for those different kinds of complaints that implicate your different powers. And that's something we're working on now, and that work will continue on into FY25. Another item that I'd like to highlight is something that was in the FY24 strategic plan, but frankly, I haven't gotten to yet, and we might get there by the end of FY24, but it's part of FY25 too. I still think it would be great for the commission to design a set of model ordinances for local governments, for financial disclosures, even for ethics administrative agencies at the local level. And I believe we have money for that. Some of that money, in order to bring on contractors to help us pull that off, would need to go through an RFP. And so I'm hoping to issue an RFP in FY24 to start that work. But that's a project that would continue on into FY25. And last, just with respect to the expansion and the building out of the staff, I want you to know that it's always felt like we've been on the limit since we've begun. In the beginning, it felt like we were on the limit of what we could handle when it was just Walker and Sonny and me here. And it's never changed. No matter how many additional staff we add, the work increases in a commensurate way. And it's always felt like we're on the limit. And we're about to hire for a law clerk position to kind of be a permanent type paralegal. And so the addition of that position, the addition of Sharon's position just recently to help on the ASD side, the addition of an additional attorney one, I think should put us in a kind of sustainable place to where it doesn't feel like we're always on the limit of our capacity. As you know, the statute is enormous. The duties of this commission are enormous. And it's always felt like, to me at least, that we're on the limit of what we can take on. And so that's an overview of the budget request and some highlights from the plan in FY25. Generally, the plan for FY25 is to continue what we've been doing, to continue building and taking on more cases and doing our core work of adjudicating administrative complaints, issuing advisory letters and advisory opinions, and filing and winning lawsuits when we need to do that.
Thank you, Jeremy. And so this does require commission approval, obviously. And so I would request first a motion and a second to adopt and approve the budget request and strategic plan, and then we'll go to discussion. Is there a motion?
So moved.
So moved. Second.
There's a motion and a second. Commissioner Baker?
Jeff, you're muted.
I'm in favor of it.
Okay, thank you. Commissioner Bluestone?
We're just on discussion now rather than a vote. Isn't that correct?
Correct. This is just a discussion.
Okay. I gather the budget has already been submitted, but I did send you in some typo suggestions. Did you get those, Jeremy?
I did, and to the extent they were typo suggestions that are part of what the state calls BFM, the budget submission request process, that the typos are baked in.
Okay. What could you explain on, I guess it's now page SEC 24 under the major issues. It talks about in addition to this staff of 6, we'll hire 2 additional positions, the attorney 4 and the state investigator, which are necessary for the commission to minima, and then it just ends. And I just wondered what you were intending to say there. To minimally meet our needs or something like that?
Yeah, that's right. To minimally satisfy the constitutional and statutory duties of the agency, I think is how that sentence should have ended.
Okay. In the strategic plan, I guess it's on page SEC. Well, in an earlier version I had, it was SEC 52. I'm not sure if that's the same right now, where we talk about doing op-eds, opinion and editorial pieces. I guess it's now page, here it is, page SEC 51 on the last version you sent to us. You've got a bullet point the third bullet point, develop and offer trainings, opinion and editorial pieces, and continuing legal education and others. And I know you have some specific goals on doing responses to advisory opinion requests in certain number of days and to complaints to respond to in certain number of days. Would it be appropriate to add in a goal of, say, a minimum of 3 opinion and editorial pieces a year? Or what are your thoughts about that?
So, Chair, Commissioner Bluestone, to be honest, I'm not comfortable committing the staff to a minimum number of op-eds. I mean, the attorney staff are full on with administrative cases and with their pieces of litigation. I mean, I don't think that you and I see the op-eds in the same way. For me, the commission's media plan, I think, should be built around earned media. I think earned media is so much more effective than op-eds, which are basically like attempts to garner free advertising. I think if the commission wants to do advertising, we can do that. We can buy advertising. I spoke at the New Mexico Press Association on Saturday and had an opportunity to talk with the newspapers around the state about the commission, its growth and its successes, and had a long conversation with Sammy Lopez about the newspaper business in New Mexico and advertising in New Mexico papers. But I just believe that the way to increase our media presence is through earned media. And I'm not against doing op-eds from time to time. I don't want to say that I am, but I just don't think it's a very efficient use of attorney staff time. And and to be honest, the production of op-eds, you wrote a great procurement code op-ed for the commission's consideration. We prompted ChatGPT to write an op-ed about why state employees should follow the procurement code. In 3 seconds, ChatGPT produced something that was rather similar. And so it just makes me wonder about like the direction that letters to the editor and op-eds could go. It makes me wonder about the usefulness of that way of engaging with the media, and who's actually reading op-eds versus who's reading the stories to steal from Judge Lang when the airplane crashes. And I just think that earned media is the way we should focus. And so I'm reluctant to commit the staff to a particular minimum number of kind of letters to the editor or op-eds per quarter or per year, but we will do what the commission tells us to do.
Thank you.
Well, I appreciate that, Jeremy. And I certainly have a lot of admiration and respect for you and the staff and the work that you do. And I agree that the number one priority is the cases that we handle and process, and the advisory opinions that we issue, and what you call any earned media that results from that good work. But I do, I guess, have a disagreement with you, and maybe it's worth having it as an item for discussion, if not now, at another time, either in this meeting or elsewhere, about the desirability of having more op-eds. And if you object to any numerical number being placed on it as a goal, we can continue that discussion. But it seems to me that in preparation for every legislative session, to talk about what the priorities are of the commission is an appropriate educational piece to advise the public about what our priorities are and what we're working on. I think even if it doesn't get published, a statement of what we're doing on the Financial Disclosure Act, both in terms of trying to provide compliance with the existing law and the laws that we've already endorsed as bills, not laws enacted yet, but the bills to improve significantly the operation of the Financial Disclosure Act, and to provide some real disclosure and information to the public that currently isn't being provided, to come up with opinion pieces that explain significant court decisions, whether the New Mexico Supreme Court or federal courts like the U.S. Court of Appeals for the 10th Circuit on Campaign Reporting Act cases that have come down. I think that there are many opportunities for our commission to do exactly what the strategic action says on providing opinion and editorial pieces. And I don't know, maybe you and I just do disagree and we'll have to leave it at that, but I would like to see more consideration of reaching out to educate the public about what the commission does, what its responsibilities are, how it's executing them, and what we're proposing to provide more compliance with ethics operations in government. What you've just talked about is developing the local government model ethics codes is another good example of a piece that I think could provide good education to the public and help garner support for things like that to be adopted and approved. So I don't want to belabor this now, but I am open to having a discussion and getting more input from the commissioners and a dialogue with you on how you maintain your priority work on the cases and the advisory opinions, but that how you also stay true to the mission of our strategic action to provide opinion and editorial pieces that educate the public about what the commission is doing and what important governmental ethics issues we are addressing and that we want to see the legislature and others continue to address. So I've made my comment. I don't know if others want to follow up now or if you and I should put it down as an agenda item for a future meeting. But I do think it's an important issue that merits commission input at some appropriate time.
Thank you, Stuart. Commissioner Castillo, anything on this motion?
No, not really. I agree with Commissioner Bluestone that education is certainly part of what we do. It's fine to have a discussion about this later. This is a question for Jeremy. Do we have a media plan that's written out, or is it, where are we on that?
Well, the answer to that question, I think, is no. There's no kind of published media plan. Tom and I are working on ways to increase the commission's visibility in the media. So that's what led to the presentation to the Press Association last weekend. Tom's trying to get a meeting with the new editorial board of the journal set up. Basically to have meetings with the editors when we don't have necessarily something ready to go. And so that they, but that when we do, they're familiar with us. I am looking at advertising and an advertising budget. I know that the newspapers, the small community-based newspapers that have still not been bought out by Gannett are still interested and need, in some sense, government subsidy. And I just have the sense that if we advertised about the commission in those community papers, State Ethics Commission, protecting the public trust since 2019, if you need to tell us something, here's how to do so. I think that will result in more presence in the local papers around the state when we have something to report or an op-ed to send in. And that's kind of where in addition to the commissioner's media policy, I mean, that's where we are on putting together a media plan. But we do press releases often, and you can always go to our website to see the press releases that we're putting up. And to that end, we're rebuilding and pruning our media contacts as they turn over, and they are turning over. The Journal just got rid of the two journalists that covered state government, and so we're trying to understand ourselves who are the people in New Mexico government and in the media that are covering New Mexico government. A couple of weeks ago, Walker and I went up in the evening to a fundraiser for New Mexico in depth and talked with people in this space. So it's not like we're doing nothing. We're doing a lot. And we're doing what we can with the resources we have to try to get the commission in the public's view.
It seems to me that this is just part of this bigger picture that you're working on. And, I just want to say that, putting together this budget, working with all the different areas of what we're tasked with is a big job. And so I think that we just put this in the area of things that we need to look at, as you do with many of your other areas, because I think it's important, and it seems to me that you're already working on this. So thank you.
Thank you, Commissioner Castillo. Commissioner McMillan?
Thank you. I don't have any pertinent input at this point.
Thank you, Commissioner Solomon.
No additional input. Thank you, Mr. Chair.
Thank you, sir. Commissioner Villanueva?
I agree with Commissioner Baker and Commissioner Castillo. I think it'd be very useful to get the information out. I worked in a group where we were required that the entire organization was required to submit news releases every day and op-eds at least once a week. And this is in a larger city, and I think the public was interested in hearing what our group had to say, and looked forward to seeing them. At least that's the input that I heard. So having worked in that area and having overseen some of it, it is an enormous amount of work. And in addition to writing, you have to come up with the content. So just wanted to also, to Commissioner Castillo's point, as we work with the Garrity group and they work on media relations, I think the more we work with them, the more they'll develop a relationship with the press, with the media, and that'll improve our coverage. So again, it seems to me like Jeremy has that he's got that on his agenda and he's working on it. So I think it's a good start.
Thank you. All right, there's a motion and a second to adopt the budget.
Mr. Chairman, could I interrupt before we take a vote?
Sure.
I'm sorry, but there was one other issue I wanted to ask about on the strategic plan. It's on the current page SEC 54, point number 2 under considerations for the relevant for the strategic plan for fiscal year 25. And I've written to Jeremy about this as well, where we note that under our State Ethics Commission Act, any public official or state employee who's a respondent is entitled to representation by the Risk Management Division. And we've seen how they have an incentive when they're the lawyers paid for by Risk Management to just file any and all motions, and there's no control on what they do, and they get paid for every motion and all the work they put on representing a respondent. And this strategic plan notes that after consulting with other state ethics commissions, that this provision stands as an aberration among other state ethics regimes. And I just am wondering, I know we've talked about it before, but will you be developing, Jeremy, a proposal, whether or not it's relevant in this next session, although because it involves state funds, it may be germane, on how that provision might be amended to provide a little bit more reasonable implementation rather than this unlimited source of funding that has to go into doing anything and everything the lawyers want in these administrative complaints. And I would just like to get your comments on that before we vote on the strategic plan that notes this problem, but I'm not sure if we have a recommended solution on how to address it. And that's what I'd like to hear about.
Well, the way that we're addressing it is by continually asking the legislature for funding for attorney positions so that we have the ability to litigate with risk counsel in these cases. I mean, we should be very thankful that we have Walker, who's a real lawyer and who can handle all of this. And we have year after year added attorney positions to help us in this regard. To be honest, I don't think we should ever ask for the state. I would be very nervous about any bill that opens up the State Ethics Commission Act, and this is in the State Ethics Commission Act, and that's kind of where I see amendments to the State Ethics Commission Act. I think we're always on defense in that regard, and so I don't have right now a plan, a legislative strategy for a bill that opens up the State Ethics Commission Act. You'll remember the last night of the 2019 session when the Senate got its hands on the State Ethics Commission Act, and there were floor amendments for hours. And every time I see a bill with respect to the State Ethics Commission Act, it makes me very, very nervous. And I just don't know that it's in the commission's best interest to create one of those.
Well, I appreciate those comments. Thank you, Jeremy. And I understand the risks that are run in ever opening up the State Ethics Commission Act. Of course, there may be bills that others introduce that open it up anyway. But I think that it's worth at least having some discussions for you with risk management on whether they see any avenues for amending this, what you've described as an aberration among ethics laws around the country. And just thinking out loud, I'm not sure that there's an effective way to do it, but if there were some way of putting a cap on these costs, or having a cost-sharing arrangement where motions are repeatedly filed and lost, or where the case is lost, that some reasonable cap might help address this problem. And I hear what you're saying about not wanting to open up the State Ethics Commission Act, but I do think that this issue is a chronic, gnawing one. And I would hope that you would be able to engage with risk management, your staff, to come up with some proposals that we might consider at some point, if and when it's determined appropriate to go forward with it. That's all I have, Mr. Chairman.
Thank you. All right. Then back on the question, there is a motion, a second, to adopt the budget request and strategic plan as in its present form and as submitted. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
Chair votes yes. The budget and strategic plan are approved. Thank you. Public comment. Walker, I understand that an abundance of humility, you have passed this task on to someone else to run this portion.
And as you're aware, Chair, Jane is far better at the tech stuff than I am. So I'm happy to have her take on this weighty.
Okay. It is a weighty matter. Jane, you're up.
Hello. Yeah, so public comment is open. If there's members of the public that would like to speak, I ask that you raise your hand. You can do it by the bottom of your screen. There's a reaction button that you can hit, and it says raise your hand. So if anyone would like to speak, go ahead and raise your hand, and I'll call on you in the order. We just ask that you identify yourself, any agency affiliation, and go ahead and give your comment.
And just to note, there is an opportunity for further public comment near the very end of the agenda. But for now, anyone? Jane, I'll let you figure it out. You got any takers?
So right now, no, it looks like no one's raised their hand for public comment.
I actually have a comment that was sent to me that was a comment that was provided by the New Mexico Foundation for Open Government. on the media policy, and it was sent to me, and I guess I would just read it into the record, since they don't seem to be here to present it themselves. That I received an email that I'm happy to send along to you, but Fogg's comments are as follows. Regarding number 2, and I guess this is going back to the proposed media policy, they said, most newspapers may require the title be included in the byline. The commissioner could still make it clear in the column they are speaking as an individual. Regarding number 5, Fogg understands the reasoning behind this, but Fogg does not endorse this. Reporters are under tight deadlines, and many agencies use this as a way to delay responses. It also restricts commissioners' freedom of speech. Fogg believes this is covered in number 4. And then regarding number 6, they wrote, it makes sense for op-eds or letters to media be looked at, but requiring that every communication be vetted hinders the news gathering process and the public's right to information, as well as limiting commissioners' freedom of speech. I hope this helps. That was submitted to me by Melanie Majors, the executive director of the New Mexico Foundation for Open Government.
Thank you. Anybody, any other takers, Jane?
No, I'm not seeing any.
All right, then Chair will entertain a motion to go into executive session per applicable statutes.
So moved.
Second.
Thank you. It's moved and seconded that the commission go into executive session per statutes as cited on the agenda. Commissioner Baker. Commissioner Baker.
Yes.
Commissioner Bluestone.
Yes.
Commissioner Castillo.
Yes.
Commissioner McMillan.
Yes.
Commissioner Solomon.
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Okay, thank you, and we'll give the staff a second to put us into our own room. Thank you.
Commissioners, do you see on your screen where it says to join the room?
All right, so the next can open. And this meeting is being recorded, I am told. So, item number 16, authorization of civil action. Jeremy?
Yes, sir. Thank you. The commission staff request a motion for authorization to file a civil enforcement action against a local elected official for violations of the Governmental Conduct Act as memorialized by Resolution 2023-06 as amended.
All right. Is there a motion and a second to adopt the resolution and authorize the action?
So moved.
Thank you. There's a motion and a second. Is there any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva? Judy, I think you might be muted. Commissioner Villanueva? Is she with us?
Yes, thumbs up.
She gave you a thumbs
Okay.
up.
With us.
All right,
All right. I couldn't get.
Okay, that's fine. Oh, hi, there you are, Judy. Okay. Chair votes yes, the motion carries. Resolution is adopted and the authorization is given. Number 17, A. Becky?
Chair, Commissioners, Commission staff seeks the Commission to issue a default order in case number 2022 NP19, which is Enri, the Commission of Mia A. Valdez.
Thank you. Is there a motion and a second?
So moved.
Okay, it's been moved and seconded. Commission, any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yeah.
And chair votes yes. Thank you. And B was previously removed from the agenda. Thank you, Becky. Item number 18, settlements and administrative matters. Walker?
Thank you, Chair. And to try and speed this along, I'm happy to, and as I understand the settlement approval votes are all unanimous, I'm happy to take these all in one vote and just list them out. Is that the sense of the commission?
Except that Ron needs to recuse from 38,
right.
Or Commissioner Solomon, excuse me.
Yeah, why don't we go ahead and do them individually?
Okay, sorry about that. All right.
That's okay, but you don't need to go through any further explanation of anything.
Yeah. Commission staff seeks a vote approving the settlement agreement between the General Counsel and the respondent in case number 2022-45 Rodriguez versus Eichenberg.
Thank you. And in that matter, is there a motion and a second to adopt and approve the settlement agreement?
So moved.
Is there a second? No.
Second.
Thank you. Moved and seconded. Any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yeah.
Chair votes yes. 18A, which is 2022-45 settlements adopted.
Right.
Item B, go ahead, Walker.
Commission staff are seeking a vote approving the settlement agreement between the General Counsel and the respondent in case number 2023-31 Ramona Goolsby versus A Stronger New Mexico.
All right. Is there a motion and a second to so adopt and approve?
So moved.
Thank you. It's been moved and seconded. Any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yeah.
Chair votes yes. Motion carries. The settlement is approved. And the third one, Walker?
Yes, commission staff seek a vote approving the settlement agreement between the General Counsel and the respondent in administrative complaint number 2023-38 Ramona Goolsby versus Brian Colon.
Okay. Relative to that, is there a motion and a second?
So moved.
So moved. Second.
All right. Moved and seconded. Any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
Chair votes yes. The settlement is approved and adopted. Item 19.
We have one more settlement agreement.
Yeah, it's not on my agenda here, but I know there is one more.
It's 2023-35. Chair and commissioners, commission staff seek a vote approving the settlement agreement between the General Counsel and the respondent in case number 2023-35 Ramona Goolsby versus Greg Zanetti.
Thank you. It for some reason isn't on my copy of the open meeting.
It was subject to an amendment at the beginning of the meeting.
That's why it's not on there. Thank you. Okay, and I will note the recusal of Commissioner Solomon, both in closed and in open session. So is there a motion and a second to approve the settlement?
So moved.
Second.
Thank you. Any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Okay. Commissioner Solomon is recused. Commissioner Villanueva?
Yes.
And chair votes yes. So the settlement is approved. Thank you. Thanks, Walker. We'll now move on to item 19. Jeremy?
Okay, commissioners, the staff seeks 90-day extensions under section 1016G11A for administrative cases 2022-27 and 2023-25.
All right. Is there a motion and a second?
So moved.
And any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
And chair votes yes. 90-day extensions granted on those two. And as to number 2023-18, did we pull that? Jeremy?
Okay, thanks. Chair, you indicated that you were recused on 2023-37, and so I'd like to ask for a motion for dismissals of certain claims in that administrative matter that are outside of the commission's jurisdiction.
So moved.
Second.
All right. Any discussion? Okay. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
And chair recuses. 6-0, matter carries. The matter's dismissed. Okay, next, Jeremy.
Okay, thank you, commissioners. For administrative cases 2023-27, 2023-34, 2023-36, the staff seeks dismissal of certain claims in those administrative matters that are outside of the commission's jurisdiction, as will be reflected in the respective and individualized orders in those matters.
Thank you. Is there a motion and a second?
So moved.
Thank you. Any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
Chair votes yes. 27, 34, and 36 are dismissed.
Okay, thank you. And lastly, in administrative cases numbers 2023-26, 23-28, 23-33, 23-40, 23-41, 23-42, 23-43, 23-44, 23-45, 23-46, the staff seeks dismissal of those administrative complaints for the reasons that will be set forth in their respective and individualized orders.
Thank you. Is there a motion and a second?
So moved.
Okay.
Thank you. Any discussion? Hearing none. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Castillo?
Yes.
Commissioner McMillan?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes.
Chair votes yes. All right. Thanks very much for that. Next meeting, we've got a few hiccups that have been caused by by the calendar, essentially. It's the end of the year. We've got a couple of things we have to do by the end of the year, so we're going to need to meet at least once in December prior to our next regular general meeting. Right, Jeremy?
Well, commissioners, we need to have a December meeting so that you can approve the annual report, and then which we have to by statute issue to the governor and the legislature by the end of the year. So we have to have a December meeting for that reason, and we'll have some other items for you at that meeting. And then commissioners, I very much encourage you to hold oral argument in Eichenberg versus Montoya, an administrative matter that has been appealed and cross-appealed. And so I'd encourage you to try to find and schedule a time for oral argument in that administrative case.
Jeremy, it sounds to me like you're advocating for two separate meetings, one distinctly for that latter matter, which makes sense to me.
It doesn't matter to me. It's up to what y'all think in your calendars, of course.
Okay. What's the pleasure? Well, let me back up before we get there. Relative to the annual report and timelines relevant in the Eichenberg-Montoya appeal, what sort of deadlines do we need to be concerned with, both on the early side and the late side?
Sure. So the annual report, we can have that prepared for you by an early December meeting, and then I hold it and then normally send it at the end of December. The timeline that really matters is the briefing on appeal in Eichenberg versus Montoya might not be complete until November the 29th. That's when we think that all briefing would be in. And so there is that consideration.
Okay.
And then Walker, Becky, and I will be attending the Council on Government Ethics Laws National Conference in Kansas City the first week of December. But I think that we should be back by Friday the 8th. Should the commission want to meet on Friday?
So, what's the appetite for having a December 8th meeting to cover all the stuff that Jeremy has just mentioned?
Well, let me ask a question. We basically need to do two things. One is the annual report, the other is the hearing. How long do you think we ought to budget or schedule for the annual report part of a meeting? An hour, half an hour?
We normally get that item done in a half hour.
Yeah.
Okay.
But that's my recollection.
And then with respect to oral argument, what do you anticipate? How much time should we schedule for that?
Well, I believe it would be how much time do we choose to allocate for that?
Okay.
Rather than leave it open-ended, I would, and Celia, you may certainly probably weigh on this better than I do, but if you leave it open-ended, it could go on ad infinitum, other than saying you each have 15 minutes, and if you want the rebuttal time, it's taken out of that. But I would...
I like the idea of allocating the time. I think it helps the lawyers that are doing the oral argument.
Right.
And what we normally did is allocate 30 minutes and 30 minutes. And if you have rebuttal, then you take it out of your 30 minutes.
Okay.
And in this case, as I understand it, there might be 3 appeals, so to speak.
Yes, sir.
There's the intervener and then there's the 2 parties. So if we do 30 minutes, then that's really 90 minutes.
In some of those cases, we did 20 minutes, 20 minutes.
Anything more than that is going to be filled productively or otherwise, in my experience. So I would agree with my learned, formerly superior colleague in our...
And then my next question, in reviewing the material, I remember, I think it was Jeremy who said that this would be a whole record review. And so could the judges on the commission tell the rest of us what a whole record review consists of?
Sure. And in keeping with the aforementioned deference, I'll go first, and Celia can clean up my mistakes, for which I am grateful. A whole record review does not... What it does not do is involve going back and looking at the case as if it's not been heard before. That would be a de novo review in which you start all over again. Nor do you attempt to elicit new stuff from the lawyers. What you're looking for is a review. Everybody's familiar enough with the record by the time of the hearing to where you've reviewed everything that has happened on the record and in the record, and that's what everybody is stuck with.
Understood. And my understanding, and correct me, is that there has been a decision. There are now 3 unhappy lawyers to some extent,
right,
who want that decision to be changed to some degree.
Yeah.
And so in reviewing the underlying record, I guess the question would be, is there enough information in the underlying record to support what the hearing officer determined?
Correct.
Which requires, I think, each of us to actually read the entire record.
Yes, and I'm sorry, Jeff. I presume that, yeah, prior to any hearing, you'd have to be more than a little familiar with what that record is, and it's provided for.
Right. And so my next question is, how extensive is the record? How long is it going to take one of us, each of us, to read it and be reasonably familiar with it?
That's a Jeremy question.
Chair and Commissioner Baker, Jane compiled it the other evening. You have it. Jane, how long was the record?
It was 863 pages.
Oh, wow. That's all?
Yeah, you could get through it in a day, 2 days maybe.
But Chair and Commissioner Baker, as I mentioned to you in correspondence, I'll provide a bench memo so that I can provide the law on what whole record review is, and just the statement of the law as to whole record review, and that's something that I've done in the past.
Yeah. And let me make one more observation. We're going to need enough time between now and whenever we have this hearing to read, for those of us who intend to read the entire record, to read the 863 pages in addition to the bench memo. So I just, because I understand Bill suggesting that December 8th might be a good date to have this, I just throw out the question, will that give everyone on the commission enough time between now and December 8th to read the record and then have the hearing on the 8th?
Yeah, I can answer for myself only in that regard, and I think it's plenty of time. But
okay.
I don't pretend to for a second to speak for anybody else. But
I mean, in case people have trips.
Right.
I have my calendar had that our normal meeting would have been on December the 1st. And unfortunately, another meeting has been scheduled for me on December the 8th, but that meeting should only go till noon. So I would have the afternoon free on the 8th. I will say, I don't know how much time staff needs to prepare for the arguments if we have it on December the 8th. Maybe it's better to have it the next week, because you all will just have been gone, just have returned from your several day meeting.
That's correct. Thank you.
Yeah, I can't do the afternoon of the 8th. I can do the morning of the 8th. So Celia, before we get too far afield on that, do you want to weigh in on this matter of the whole record review, or have we covered it?
I think your description is good, because you have this ability to put it in real people words, which I think is very helpful. The only thing I'd add is, are we not limited to the issues they bring up in the briefs?
That's correct.
So that would be the only thing I would add.
Okay, so anybody else, I mean, relative to the date, what about December 15th?
That works for me. One more comment.
Okay.
Do we want to do this by Zoom, or do we want to do this in person?
Well, I think ideally we want to do it in person. That's the way this all works. always works best. I don't know about the practicalities of that, given our friend from Carlsbad and a couple of the others. But in responding to the is December 15th okay? Could each of you take into account Jeff's question?
I'm fine.
Works for me.
I'm fine.
Stuart, you good?
Good with the 15th.
I'm good with it.
Ron? And
December 15th is good for me. It's better than the 8th, that's for sure.
okay. Dr. McMillan, are you good with that?
Yes, I'm fine with the
okay.
15th.
And Judy?
Does it have to be on a Friday?
No, it does not, but it just Fridays we always did, and I think it's because they tended to be before or after a weekend if there was travel involved. There were several reasons that were really good at the time. I don't recall what they are, but at the moment, but I know that's what it was. But the answer is no, it doesn't have to be.
Okay, I'm good for the 15th. You're saying how much time are you saying that might take?
Well, we're looking at a half an hour for the annual report and an hour for the oral argument.
Are we going to discuss the case after the oral argument?
Well, there will be some discussion, but we don't know how that'll long. But I would guess that it would not take more than a half an hour. In
I would add at least the half hour after the oral.
Yeah.
Okay.
And Jeremy, if I might, is there a deadline on making a decision?
You have to have oral argument by November 29th if there is oral argument. So if you order it,
it's December. I think you meant December
29th.
I'm sorry, December 29th. And then you have to issue a decision 180 days after the notice of appeal. So sometime in the summer.
Right.
Okay.
So we don't have a constraint on the back end other than, in my experience, the further you get away from the information coming in, the worse off you are trying to figure out what it is you intended to do.
So, and I would agree with that.
Yeah. So can we start with, I would suggest we go with Judy. You're really the most important actor in this. Would you prefer Zoom or in person? Because if we do it in person, we'll need to do it either in Albuquerque.
Let me ask you this question. Isn't it possible for us to do both?
Yeah, that's I just thought of. Yeah. In which case, I would suggest we just do it on Zoom. I mean, I think it's preferable to do it, but in this day and age, I'm not sure it really makes sense. But Jeff, you raised it, and I think it's a good issue. But
I think Judy was suggesting a hybrid.
Yeah, it is, but a hybrid is the same as Zoom. So
we could accommodate that. I believe we could set you up, Commissioner Villanueva, to where you could hear the arguments of counsel and ask questions virtually. I've seen the Supreme Court do that, even out of the Supreme Court courtroom.
Yeah,
I think that we could figure that out.
Okay, and if anybody else finds themselves in the same position, they could be accommodated as well. Okay.
I'll try to be there in person. If I can't, I'll let you know.
Yeah, but understood. I mean, that's a pretty long schlep for that period of time. If we were doing something over the course of 2 days, which mercifully we are not, I would get it. But I would propose that we started with the oral argument at 9 o'clock, and then set the other for 11. Just to be an abundance of caution and also giving us a deadline. Is anybody opposed to that? Okay.
And one final question.
Yeah.
Do you have black robes for all of us?
You have to furnish your own robe.
That's right. You're on.
It doesn't have to be black. You can
thank you.
Whatever color you want.
I had a green one at one time. So there are many, many colors. Okay, so we are good on that. So in terms of a next regular meeting, should we deal with that now? I would guess that we'd probably want to go back to our old cycle, which would have been, well, there's December, February, but there is a session coming up. I don't know. What's the, or we could defer making that decision until December 15th. What's the pleasure of the group? No more meetings? Is that what I'm hearing?
Wrap it up.
Yeah, I think that we need to ask Jeremy what works best for him.
Yeah.
I like knowing what the date is, because that way I don't.
Yeah. The sooner the right. Yeah. If we're going to wait until December to set the meeting, it really can't practically be before February, I don't think.
I think that a February meeting probably makes sense, since we'll kind of clear out the items we'll have for you come December 15th. And
yeah,
this is only a 30-day session. I mean, it's just a few budget hearings, so it's not like the session will dramatically impact our work. But probably a February meeting gives us some time to accumulate what we ordinarily do to present to you.
Puts us back on our even month calendar. So what's the first Friday in February? Anybody know?
Second.
Okay.
Groundhog Day.
All right, Groundhog Day. So we'll set the next regular meeting for February 2nd of 2024.
And I just want everybody to know that February 2nd will be my 50th wedding anniversary.
Wow.
And I will expect appropriate high fives.
The long-suffering Mrs. Baker is welcome to join us for an award. Yes.
Yeah. Hey, she should get multiple awards and rewards.
That's up to you. All right. So I think the last item would be additional invitation for public comment. Jane, you want to check with your audience?
Yeah, so if any members of the public would like to speak, you can go ahead and raise your hand. You can find that feature on the bottom of the Zoom options with reactions, and it says raise hand. So if anyone would like to speak, go ahead and raise your hand.
No takers?
Yeah, it looks like no one has raised their hand.
All right, no public comment. So nice to see everyone. We'll see you next month on the 15th, and we're adjourned.
Thank you.
Thank you.
Thank you.
Thank you, everyone.
Good to see everybody.
Safe.
Have a good
Take
weekend.
care. Everybody
Take
be
care.